when you wanted to learn about InfoWars finances? I just want their identities at this point.
We're early.
All of the people I've spoken to?
Yes.
Okay, so initially when I went down to Texas, I spoke to a gentleman named Bob Rowe.
Mm-hmm.
And most recently, I've spoken to Mark Schwartz.
Who is Mark Schwartz?
Your Honor, maybe this sidebar, please.
Certainly.
Short notice, doesn't matter. I missed the better part of today, but what I started catching up on this afternoon, fascinating. Fascinating from a legal perspective, from a performance perspective, from a the practice of law. How's my audio? How's my makeup? Need some powder. Rat's nest on my head. What am I looking for? Chat. I'm looking for settings. Everything looks good. We're live on both platforms. Okay, let's see what.
This is well within the scope of direct. She was asked about this.
On Rumble, it says, now I'm curious.
She said, I'm not sure I can ask. I can answer where these numbers come from. And I think they can choose as to those citizens.
Right now, I think the question that they're on, that's the issue.
To the degree that they want to argue.
They're trying to get questions about the deplatforming of Alex Jones and Trump.
Trying to argue punitive damages in a compensatory damage case. I think the jury is entitled to know that Alex Jones's company is now rolling in cash, but it's broke.
He wants to get bankruptcy in evidence.
Did she can say
that the company's broke, not rolling in cash.
Yes. You don't get to pick the points I make. No, they tell me it's sort of like the notice here.
Pattis is
curiosity. And what are you going to do? Move on?
Yeah, absolutely.
There's no point in that question. That there's only one point, and it's an improper one. So sustained.
I don't think so. I think the question was, is well, I'll be honest with you. I don't think briefing in court.
Yeah, what a day. Well, I missed a good portion, which we're going to have to rewind. They're ending early. Apparently, the jury's being dismissed at 3:30. They're going to argue some motions, so we should be able to skip back and just watch maybe at 1.25.
Why don't you two talk and give me a so when I just told you we're going to leave it.
Right, exactly. I'm going to be hours.
Pattis's hair is so long.
You're an expert.
Yep, I'll get to that as well. Let me start this. She sustained an objection, a request for judicial knowledge that Trump was elected in 2016. I'll get to why it's totally irrelevant because the jury heard the question. And it doesn't matter if they then get the answer. It is judicial knowledge. Everybody knows what happened in 2016. It caused a seismic shift in reality itself. Is my mic good, people? Yeah, I heard about that too. I ordered a MyPillow. We'll see when it gets here.
Back, so we're not going to go past 3:30.
What is happening with the guy's hair? It's long hair. I mean, that hair has to be growing for years, like 5 years, easy. Good, Mike? Good. Audio good. Very nice. Yes, Mike, good. Mike is fine. Good. And let's see. Rumble, how are we doing on Rumble?
Proposal is?
Good.
Okay. And we're going to let our jury go at 3:30.
Yeah, we heard.
I asked for a sidebar before objecting. May I object now to that question, or is jury Pattis going to move on?
I think the court sustained the. I mean, if you didn't, it sure looked that way.
I thought it was caught on the sidebar. Your objection is sustained.
This is true, David. The judge refused an objection to take judicial knowledge for the jury of the election of Donald Trump in 2016.
And you offered testimony about Tim Frei-Day.
Yes,
Do you know whether he is a current InfoWars employee?
he's not.
You were asked questions about daily sales reports that Frei-Day offered, correct, or created, correct?
Yes.
Was there a file somewhere of all those daily sales reports?
No.
And I don't know if I asked this, did they even have a server that everybody had access to in that building?
I didn't see one.
But yet you saw a number of emails that came from an InfoWars server, correct?
I did, yes.
I'm not reading some of the chat, although
You
I'm
were asked
reading it.
questions
I'm not
about
bringing it up.
Henry USA.
I remember, yes.
And Henry USA, you told us, was a gun manufacturer.
I think that's what it is, yes.
And you spoke about a second gun manufacturer that InfoWars solicited business from, and I don't recall its title. Do you?
I'm sorry, I don't.
What was their, based on the records that you observed, what was their advertising base? In other words, where were they soliciting ads from?
Who?
Just your time period?
Fair enough, from 2013 to the present. That's too broad a period to be meaningful, tell me.
When you say they soliciting, you mean free speech?
Mm-hmm.
Is free, okay. I mean, generally, the base which they are soliciting from are conservative listeners and people who are interested in conservative politics, and gun owners would tend to be interested in such a thing.
Was that in response to a question about advertisers?
Yeah, I asked about the advertising base.
Should I go let the chat and law and crime know that I'm live? When is DeSantis? Hold on, I just saw. When is DeSantis sending me to Martha's Vineyard? I don't like islands, by the way.
An exhibit, I think it was 216, which was one of their media kits, and media kits were things that were prepared annually to solicit, presumably ads and so forth.
I believe so, yes.
This
They
is
refer to themselves as kings of their domain, correct?
Yes, I think in multiple of those.
I can
that's how
pause
they-
it for 1 second. This is a corporate representative of InfoWars, Free Speech Systems, an official representative. She's been examined in chief for 2.5 days. This is Norm Pattis, Alex Jones's defense attorney, and InfoWars and Free Speech Systems, cross-examining the representative of Free Speech Systems. 2.5 days in chief. Basically, what they got out is that they use Google Analytics, they make money off of their business, or attempted to, and Alex Jones made a bunch of statements without vetting them himself or doing his due diligence. According to her, she made some admissions that were curious. Okay, that's where we're at. We'll come back to it when we have time to pause.
And rank themselves in association with others, correct?
Yes, I saw that.
Can we do 216, please?
That might make a good shirt,
Thank you.
Langford. Booyah. Don't eat wild mushrooms, people. Let's see what's going on in the Rumbles. Viva, am I adopting that dog? Can't do it. Can't do it just yet. Get a Getter account, you son of a. I can't do more social media. It's too much already.
Al is not cooperating, Judge.
We're gonna go back and watch a portion of this.
Let me move on without it.
Your Honor, can we, there's a whole bunch of material being displayed that's not in evidence on the screen.
Oh,
right
sure. Can we shut that down? No problem.
Sorry about that.
I am in Florida.
You said you didn't know
If only
much
temporarily.
about Glenn Beck?
Not really, no.
Do you know that he's a conservative talking head?
I think he is, yes. I've never listened to his show.
Did you know that Rush Limbaugh is dead?
I didn't know that.
Did you know that when he was alive, he was a conservative talking head?
I did know that, yes.
And you were asked about, I can't remember, One American News, and you described that as a conservative outlet, correct?
Judge, Your Honor, there's no question about One American News.
I thought there was.
Pattis,
Newsmax.
It was
Thank you.
Newsmax, yes.
I got it confused.
Frustratingly
That's a
good.
conservative outlet,
Yes.
correct.
frustratingly
Yes.
good of an attorney.
And here, we got it up. Thank you, John.
And I'm not saying this because of anything about Alex Jones.
WND.com. You know what that is?
WND? No.
Okay. But is it fair to say that in this chart, what they were doing is they were situating themselves among other conservative outlets to say to advertisers, hey, look, come to us, we'll get you a bigger bang for your buck.
That's what the intent appears to be.
You were never able to speak to Owen Schroyer?
No, I didn't speak to him, no.
How many times did you try?
I don't think I called him.
Owen
not?
Schroyer was a rep of the company, one of the co-defendants.
Time,
Former
for the
co-defendants.
most part.
Is he a defendant in this case?
Not anymore, I don't think.
He
was, and I think they
he's a
dropped.
defendant in the Texas cases.
I thought they dropped Owen Schroyer. Chat, did they not drop Owen Schroyer as one of the defendants? I thought they did.
You were shown emails from Paul Watson, in particular, an email at 160, that Watson was opposed to the lies of Sandy Hook. 3 years, this is how my adversaries characterized them. 3 years after shooting, there was another email, correct?
I remember those emails, yes.
And you mentioned that Anthony Gacciardi was an employee.
Yes.
In fact, he was a consultant and not a direct employee. Does that refresh your recollection?
I'm not sure if he was an employee or a consultant. I'm sorry, I don't know.
Yeah, I think Schroyer was dropped
No
as a
one
defendant.
at InfoWars had any idea how many times they had uploaded material either in whole or in part regarding Sandy Hook, correct?
Objection.
Sustained.
You are unable to determine based on your review of the records how many times InfoWars had downloaded material either in whole or in part to third-party providers,
gonna be
like YouTube and so forth, correct? You found no records to that effect.
Right.
Did you contact YouTube?
No.
Do you know, as you sit here today, whether YouTube destroyed those records? Do you know?
I don't know. I don't know if they still have them.
Trying to show why Alex could not have complied with certain discovery obligations. The argument being that YouTube deplatformed him, deleted his videos so that he could not produce what he was being asked to produce. We'll see. If he pushes this, I would imagine there's going to be another objection.
I have just 1 minute, Judge. I'm scanning my notes.
Take your time, please.
And people, the link to Rumble is pinned in the chat in YouTube. I don't know how long we'll go on both before moving over exclusively to Rumble.
Now, you, in your review of the records at InfoWars, did you find a copy of the state's attorney's report, Mr. Sedensky's report?
I believe I saw a copy of it. Yes.
And Mr. Sedensky, just so the jury knows, he's he was, at least at that point, the head prosecutor in Danbury.
Yes, he
And
was.
the state of Connecticut is divided into what are known as judicial districts.
Yes.
Steve was the top prosecutor in the judicial district of Danbury.
Yes.
And he was asked to compile and did compile a lengthy report about what happened at Sandy Hook.
Yes.
And that report appeared how many months after the shooting?
I want to say it was about close to a year later.
Where was that copy of the Sandy Hook report when you saw it?
I recall we saw the email with the link to it. I don't know if the link worked, if it was a link that you would be able to click, or if the report was just amongst the documents. I don't recall which one I saw.
Right. And in your review of the files, well, what's wrong? You've seen videos of Alex sitting at a news desk, correct?
Yes.
And behind him was a screen, a very colorful screen, correct?
Yes.
And you've offered testimony that on the table in front of him, there would be a series of printed out news stories.
Yes.
Do you know what, did InfoWars have a practice of saving the stories he commented on
Objection.
an individual day?
You mean the papers?
Right.
The
No, they
stories,
didn't.
Okay, not the
Do you know what,
videos.
based on your review of, based on your time down there, they just throw them away at the end of the day?
They-
Basis.
I didn't say that. I said based
No.
on
Old.
Basically, yeah, they just threw it away.
any filing system down there relating to the editorial function?
No, not that I could discern.
Any library videos?
Their library was YouTube.
Anyone tasked with the responsibility of keeping a complete record of what they said, when they said it, and who they sent it to?
No, at some point they made an attempt to,
Objection, Your Honor, hearsay.
Based on what you,
she's a rep.
based on the records you reviewed, Were you able to determine whether they ever made such an effort?
They made an effort at some point. They started making an effort by making the logs. But aside from those logs, no,
And you went down there looking for that stuff
I did.
with Attorney Bly?
Yes.
Nothing further, Judge.
Really? Really? He's ending it early. Are they going to redirect? Apparently they have 6 minutes before the jury is done for the day, unless the judge says, let's go. If you don't have very long, attorney, plaintiff, I don't know
There
what
was
it's.
one other question I had, Judge. I'm sorry.
I think so.
How
I think
did?
at 477, that's an exhibit that was offered today. Can we put that up?
Let's hold on.
Yes, 477 is a full number.
Judge, we're going to need assistance on that. That's a late addition. May we ask our colleagues?
What is it that we're being asked to do?
Can you
Just
pull
play
up
477.
477? It's a late addition, if you don't mind.
We have to do that, Your Honor.
Thank you.
I couldn't answer this
Let's hold
question.
on.
Yes.
Today.
Oh yeah, you know what? Speaking of moderation, hold on. Let me go put it on subscriber mode and slower mode. Subscriber.
We can display it if you'd like, Your Honor. Please.
Slow mode coming on. 3, 2, 1.
Definitely.
I think there was some writing at the top of that when I first
Oh,
saw.
we're coming back to this.
Can
No, Your Honor, it was not admitted with any writing.
Okay. You've not seen this before today?
No.
Based on your observations down there, do you believe that Alex has contempt for courts? Not on what I said,
Your Honor.
but on the videos you reviewed, the
Alex
documents
Jones,
you read.
Kangaroo
do you
Court,
believe he has
watch
contempt
day
for
one.
the American court system?
Objection.
Sustained.
You believe Mr. Jones believes that there is a crisis of legitimacy in this country?
Objection, Your Honor.
Sustained.
Nothing further.
So I guess he interesting. Oh God, that lawyer looks angry. It's interesting. Why object to that?
Your Honor, just for Ms. Paz and counsel, we're going to display 480.
Thank you.
We'll come back to that exhibit. I missed when that exhibit was adduced, but I caught up to it a
I
little
don't
bit.
think I've seen this one yet.
Adding a new exhibit in redirect that was not
Ms. Paz, do
apparent.
you see 480 for you?
I do, yes.
Okay, do you see a Bates number at the very top?
Show us the image.
Oh, yes, I see this.
Okay. And that Bates number starts with the letters FSS, correct?
Yes,
Stands for Free Speech Systems, right?
yes.
You've seen many, many documents with that prefix and number after, right?
I've reviewed a lot of material that have a Bates stamps that starts FSS and other numbers after.
Right, and when Free Speech Systems produced documents in this case, it identified documents by including a Bates number so that everybody could track what documents were being produced.
Correct, right.
And looking at that document there, that is a organizational chart that Free Speech Systems produced in this case, correct?
Objection, when and when was it created, Judge?
I'm asking the witness, this is Free Speech Systems witness.
I don't know when it was created, but it appears to have a Bates stamp on it.
Right, I'd offer it, Your Honor.
So you see,
Foundation, when?
Pattis is trying to tell her what to look
You know,
for.
Ms. Paz, that this was, because it has a base stamp number of Free Speech Systems with the base stamp number that it was produced in this case, correct?
It has a Bates stamp number, so it was produced.
Yeah, go offer it.
Foundation, what period, when?
Look at the bottom tab, Ms. Paz.
He's
Do you see that there are several years there with organizational charts for several years?
I see dates at the bottom.
What are the
Yes.
dates you see?
I see 2012, 2014, 2015, 2015, 1, 2 in parentheses, 2016, and 2017.
Okay. I'd offer it, Your Honor, as organizational charts of Free Speech Systems for those years.
Hearsay, Judge, we don't know who created it. We can see it was given up, but was it a consultant? On our testimony,
corporate
it's not.
record. It'll probably be admitted.
There's no foundation.
Okay, would you please pull up the exhibit, please, for Thank you.
Overruled. I think I.
Ms. Potts, you testified, I think it was in the first 5 minutes of your testimony, you testified that there are no organizational or flow charts at Free Speech Systems, correct?
I've never seen this before.
Right, right. But you didn't testify, I don't know whether there are any flow charts or organizational charts. You
Why-
testified there are none.
So
correct?
why give
I
her
did
the
not
chance?
see any.
Why give her the
Right.
chance to
No, I
clarify?
understand that you
Right.
didn't see any, but
It's going to
But
ask
if you didn't see any, then it would seem that the accurate testimony would be that you don't know if there are any.
I
right?
misspoke.
Well, I don't know if this was produced in preparation for the litigation, so I don't have anything to suggest that there were, and nothing in my review suggests that there were.
Okay,
So that was my testimony.
okay, but you acknowledged that you didn't review every document that was in your Dropbox, right?
This was not my Dropbox,
How do you know?
because all the information that was in my Dropbox had Texas bait stamps on it.
I see. This is going back to you saying you couldn't even tell whether you reviewed any documents in Connecticut,
That's
right?
correct.
Right, but if it was produced in Connecticut, it was produced by Free Speech Systems lawyers, correct?
Objection, legal question.
One of the lawyers,
Right.
whomever that was.
Right, well, and Mr. Pattis has been a lawyer for how long?
I'm not sure when he started, but
Okay.
sometime.
Okay, well, he was the lawyer back in 2018, correct?
Objection, it's not true.
As I said, I don't know the dates.
What about
that he was
2019?
retained. I'm not sure when he was retained.
Okay, all right. But Mr. Pattis, Free Speech Systems lawyer, stood up here after this document had been produced by his client, and the first question he asked you was whether there were any flow charts or organizational charts, right?
I heard the question.
And you said no, right?
Based on what I had reviewed, I hadn't seen anything
And
like
he didn't
that.
correct you, did he?
I don't think so.
Okay. Well, let's go to 2017. Do we have that up? Is that it? You see that?
The flow chart? Yes, I
Mhm.
see it.
Okay. And who's at the very top of Free Speech Systems?
Alex?
Right. Okay. And then you
Member.
have right below in a box titled Executive Admin. What's that name?
Dr. Jones?
Okay. So that's David Jones, right?
Right, that's
Alex's dad.
Right.
Okay. And then
Okay.
next on the
Okay.
list is Tim Fruget, right?
Tim Fruget. Show us.
Underneath sales and new product advertising. Yes, I
Okay.
see it.
Okay. Right. And do you know who Patrick is?
I don't.
Okay. Do you ever speak to somebody named Patrick Riley?
I don't think so.
You know who that is? Okay.
No.
And then you come down on the left side here on finance, there's
This is-
Lydia,
This is
right?
not
At the
a
top
flow
of the finance
chart by
department.
any
Yes.
means.
That's Lydia Hernandez,
Yes, she's not there anymore.
right? And below her is Melinda, and that's the Melinda who you were just talking about earlier.
Corporate
Right.
structure at
And you said,
best.
in response to one of Mr. Pattis's questions, there's no HR person that you know of, but that Melinda kind of does that role, right?
Kind of. I
Yeah.
believe she's a bookkeeper, but
It's
kind
not,
of.
I don't even know what the relevance of any of
And
this is,
then
other than to
Going
show
down further, if you can kind of just pull it out a
relationship
little bit,
between
Pratika,
parties,
thank
maybe.
you.
But
Okay. There are a series of departments that are listed out there. You have personal assistant Stephanie on the left. That's Mr. Jones's personal assistant. Yes.
organizational chart, maybe.
I'm sorry, where are we looking?
Yeah.
I'm sorry, it's a little bit confusing.
It is.
I'm kind of in
Shouldn't be.
column H here, where you see personal assistant on the left-hand
Oh, okay, I
side.
see it now, yes.
That's Mr. Is that Alex Jones's personal assistant?
I'm not sure.
And then over here you have household, Sarah and Samantha.
Yes,
Those are two household employees for Mr. Jones.
yes.
Are they paid out of the company?
I don't know.
Oh, they're going after undeclared revenue.
And then we're looking at these these departments down here. If we just read left to right, we have procurement, inventory, right?
Yes, I see that.
Operations, yes.
Yes,
IT,
yes,
you have a programmer, correct?
yes,
You have graphics design, correct?
Mhm.
yes.
Writers, editors, moderators,
You read
yes?
very well. What's the
Yes, I
point
see
of all of
that.
this?
Okay, and you see production over here?
I see that, yes.
Okay. Now, Ms. Paz, I know that you, at different times, haven't been sure which depositions you read, but did you read Kit Daniels' deposition?
This has got to be so
Let me
confusing
Kit's
to a witness.
deposition.
This trial's been going.
I
This
may have. I know I spoke to Kit.
litigation's been going on
You
forever.
don't recall whether you read his
I
deposition?
don't recall if I read his depo.
Okay. Well, Your Honor, we made a deal with the jury here. It's 3:30, so I don't want to keep anybody past where we are. I do have more redirect, but we'll just finish that up on Tuesday.
So she's
Good idea.
Thank you.
So
good idea. Okay.
we are not going to see you until Tuesday. You now have 3 days to make sure that you avoid any and all media coverage of this case. And of course, 3 days where you cannot give in to any temptation that you might have to go online, look anything up or anywhere else. So no research, no media
They're doing
coverage,
4-day a week, so Tuesday
no
through Friday
discussing anything that's
with an
transpiring
early
in
day
this
Friday,
time
apparently.
with each other or with anyone at home or any of your friends. or
Oh,
if
for
you go to
goodness
work
sake.
on
Okay,
Monday
they
and
got it.
at
We
work.
understand
All right,
it.
so I know you'll honor those rules.
I know you
I
will.
hope you have a wonderful weekend, and Monday, we will see you Tuesday. We will plan starting right at 10, so if you could continue to
This
do
hand clapping
prompt-
thing.
Actually, you guys are always early, but if you could keep that up, we would all appreciate it. I'm gonna stay on the record, and we will see you again on Tuesday.
Okay, so
And
now-
Ron,
now-
of
now
course, will
apparently-
safeguard your notepads.
Apparently there are some motions to adjudicate on. We'll see about that. Then we're going to go back to the dark judge meme. What does this say? Trudeau must go is upwards 200.
I'll do that again.
That's fantastic. I always feel weird, jumping on those trending bandwagon thingy things. I tend not to do it.
I'm glad you reminded me at 3:30. I lost track of the time, and I did promise them 3:30, and I
Oh,
did
God,
not.
thank
I
you.
want to keep my
Thank you for
word.
saying that. I just received some criticism from my team for ending too early, so I appreciate you saying that.
Well, no, once I tell them, I want us to keep our word.
I can't
So,
stand
we
the
have the
courtroom
issue-
politeness.
We haven't taken our afternoon recess yet, so I don't know how, I'll talk to Mr. Farrow and our monitor in a second, but don't we want to deal with for the 10th time, the FSS PQPR issue?
FSS
Is this a good?
This is a
PQPR.
great time.
All right, so just give me one moment, please, Madam Monitor.
I might have missed something because I have no idea what the FSS PQPR is. What was I just thinking about?
Can I get just, can you give me an idea of how long you think the argument will take? I want to, we didn't have our afternoon break. If it's going to be short, I think we could probably skip it and just end for the day. But if you think it's going to be a longer argument, then we have to take an afternoon recess.
You're right. I don't think this is long.
Attorney
Okay.
Pattis?
I don't know what they're gonna say. I told you earlier, I rely on my papers, so unless something surprises me, I'll be brief.
Okay, so why don't we try to see if we can do it and then adjourn for the day? Whenever you're ready.
So this was originally our motion to compel. The spreadsheet, excuse me,
A motion to compel ordering.
I'm back on the last motion, Your Honor.
Right,
okay, so maybe
and
she's on the wrong
just
motion.
so that I
Yeah.
don't miss anything, I'm gonna follow the same exercise. If you could just give me the name, date, or entry numbers, and I want to get it from both sides so that I have everything.
Okay, so
Okay,
apparently they're referring
that
to
is
a
gonna take a moment,
motion
Your Honor.
to compel,
Okay.
which is basically a motion to the court ordering the opposing party to produce something. Yeah, compel a spreadsheet. Again, I don't know the American procedure, American law. Under Quebec law, you can't compel someone to create documents.
I had the original motion for order
But let's see what this
at
is.
9:26, I think.
Let's see what's going on here.
Okay, I have the document.
I love it also, like, in a trial like this, every lawyer on the team wants not their 5 minutes, but they work hard. They want to have the face time, the argument time. So they got to, you get your lead counsel in the back standing up, and then everybody else who's been working on this, they want to get their experience. And so
That's
this,
correct, Your Honor. Sorry, I'm not standing. Motion for order at 9:26.
okay, motion for.
And then I think I have Attorney Pattis, your brief, just give me 1 second.
Here we go. Thank you.
982, filed on September 14, or no? Yes?
That's not right, Judge.
Okay, and are those the only two documents that I'm looking at?
No, Your Honor, there's a reply brief that docket number 948.
50% of law is procedure and paperwork. Now they're going through the docket, so every motion gets entered into the docket, which means that there's like 900 and some odd, at least, motions, documents filed
Yes,
in
I
the
see
court
that,
record.
948, September 2nd.
Then, Your Honor, you entered an order permitting an affidavit to be filed
9:45.
And I'm just looking for the docket number of that order.
A
And
motion.
that order permitted the affidavit to be filed.
Whose affidavit?
I believe it was Thursday of last week.
Yeah, whose affidavit?
That's correct.
In lieu of testimony, presumably?
All right, is that everything?
No, Your Honor, then the affidavit
Yeah.
was filed eventually. That was filed on September 14th.
That-
And
that's-
docket number
Yes.
982.
That's the one that I referenced.
Nothing in law.
So
doesn't
clearly
take
I'm
long.
going to consider it,
Yes.
even though it's late. It's not a problem.
That's
What's a
understood, Your Honor,
partially
and that
qualified
is
direct-
actually the reason why we need to have argument. Because, so where this started was that there was testimony from Lydia Hernandez, Free Speech Systems accountant, and from Alex Jones regarding the existence of a management agreement between PQPR and Free Speech Systems. And what this goes to, I know Your Honor has heard argument before about PQPR, but the dispute between the parties is that the defendants claim that PQPR is an actual independent entity. The plaintiffs disagree
Yeah,
with
and they
that
say
for
they
a
have
number
control
of
over
reasons,
PQPR.
including the fact
So they should be
that
compelled to
the
produce a
best
document.
evidence we have so far shows that PQPR is wholly controlled by the Jones family, has no employees, and revenue that is supposedly being generated by it has been paid into Free Speech Systems. So there is a hot contest about the existence of PQPR as a real independent entity. And so the request for the production of the management agreement
I got
goes
it.
to that
I got it
issue.
here.
There was testimony that it existed.
And so what was produced, that memorandum of understanding that was all redacted?
So that, the Mr. Schwartz's affidavit indicates that in his understanding, that's not a memorandum of between the two companies. So he says, in other words, that's not it. And the other thing that is attached to his affidavit, and this is, so he produced two things attached to his affidavit.
Yes.
The first is a 2007 document concerning Free Speech Systems corporate organization. That document is responsive to discovery requests that we made in January of January of 2019.
Oh, get your.
So that has never been produced to us before. This is more of the same in terms of shortcomings in production. Then turning on to what was attached at the end of the document, Mr. Schwartz's affidavit, the current CRO, says that's not, in his understanding, a memorandum of, I'm gonna get my, it's not a management agreement. That's what he says. So what is given to us is a document that should have been produced. I mean, that final attachment exhibit.
But his
C with the
affidavit
line-
says he doesn't think there's a management agreement.
Your Honor, it does say that he doesn't think there is a management agreement based on a review of the files, but the overall picture is that there is testimony that there was. There's
Management
more
agreement
documents that were withheld.
Between a holding
And
company
once
and
again, we're in a
InfoWars.
position where we were trying to take discovery on this issue, and we
Wow.
just don't have the full record to work with. How could we cross-examine witnesses on the existence, on their claim that this entity exists without these documents?
I understand exactly what you're saying, but wouldn't this require an evidentiary hearing? How do we know that Ms. Hernandez was not referring to the memorandum of understanding or Mr. Jones?
Your
I mean, it
Honor,
might actually be that there is no management agreement in existence, correct?
it is possible that there's no management agreement, but the difficulty here is look how far we are.
Sure.
We're just finding documents that were not disclosed to us
Oh, they're-
previously.
they're
This
just
can't be
finding
happening
documents.
in the middle of trial. And
Yet
so-
it is.
Oh
and
my, yet it is.
And so we've been prejudiced on the exploration of this question about whether PQPR actually exists as an independent entity. There's no question about the prejudice based on this record.
Right, so essentially, Mr. Jones and Ms. Hernandez testified to the existence of a management agreement, but Mr. Schwartz couldn't find one.
A management agreement between a
Mr.
holding
Schwartz
company
indicates he couldn't find one.
and Alex and
Mr.
InfoWars.
Schwartz then gave additional documents.
That
which
should have been, I understand
produced.
that should have been produced, what wasn't produced, but, so what you have is Mr. Schwartz saying, I can't find it, but you have Mr. Jones and Ms. Hernandez testifying that there was a management agreement.
Yeah, so, someone just said you've been prejudiced from this. In what
Attorney Pattis?
possible way?
The best thing that's happened to me in the 3 years that I've been in this case, in spite of 2 firings and rehirings and the court denying my motion to withdraw, is to move into bankruptcy because it's given me a management team that I can get answers from. This issue came up, Mr. Schwartz checked. I think I can tell you that a precondition of getting into bankruptcy court was trying to create some internal management accountability. It took months to get that done. I don't know that, I would be in a better position were there a management agreement because that would support an independent relationship between the two things. Frankly, the plaintiffs are better off without one. That supports their argument that they're not settling these things. I think this goes to its weight rather than its admissibility. If the court wants to have an evidentiary hearing, I think for lay people, the difference between a management agreement and a memorandum of understanding might not be that significant. As to the claim that we should have produced it a long time ago, yeah, we should have. You've heard a little bit about the situation down there.
What
You'll do what
difference
you're gonna do.
would
I'll
it
rely on
have
my
made?
papers beyond that.
I'm just trying to figure out, Mr. Pattis, why should, because I've heard your arguments, I listen to your arguments, I read what you file, and there's a picture painted of, sort of a lack of record keeping and structure and such. And it seems almost like the defendants are asking to benefit from that. Let me just finish.
Benefits. Default verdict
What
is
I
in.
have is Mr. Jones, who is in charge, and Ms. Hernandez
They want,
saying that such a document existed, and not surprisingly, poor Mr. Schwartz comes along and can't find it.
All I can say, Judge, is if you think getting ourselves into a default position benefited us, you see the world differently than I do. The failure to provide simple answers to simple questions on a consistent basis from one case to the next, from 1 month to the next in the same case has been my client's undoing. You gave me the opportunity to get an affidavit.
I like
got it.
Pattis.
It speaks for itself. I would ask the court to not enter additional sanctions. At some point, the plaintiffs, should be required to prove their case on the merits.
Yeah, too
From
late.
the day I got involved in this case, everything was an emergency. This had to be done in a hurry, and there's been a false sense of urgency attending this case from day one.
Pattis is
We're here now. I actually don't think the plaintiffs are prejudiced by this. I think they'd be prejudiced if I came up with a management agreement that tended to show independence. In fact, I now have somebody who's looked and he says there isn't one. Whether his opinion that this, I don't think he can have an opinion that this is what the declarants we're talking about, meaning Ms. Hernandez and Mr. Jones. I think it's supposed to wait rather than that.
Well, I'm just sort of left to
Just-
guess as to whether
Yes.
Mr. Jones or Ms. Hernandez was in fact, they were mistaken and they were actually looking at the MOA instead of
A memorandum
management
of
agreement, and I
agreement
shouldn't be left in that position. I'm not
between
going to rule today.
A
I'll
holding company
wait
and
in
the
day.
defendants.
What what are the plaintiffs asking for?
Okay, good
I'm
question.
not saying
What
you're
we're
getting it. I
asking
just
for.
Super
want to know
duper
what
double
you're
default.
asking
Yeah,
for.
and may I respond briefly?
Ultra mega
Attorney
default.
Patterson?
Sure.
Your Honor, there has been sanction after sanction
Yeah.
after sanction.
Get another
and
one.
the notion that non-compliance at this point is anything but intentional just makes no sense at all.
No,
Sorry.
Well, I just want to say that there's no suggestion that it's Attorney Pattis.
Your Honor, that is correct. That is correct.
We want ultra,
So
super duper mega
What we are
sanctions.
requesting, Your Honor, is the response to what we were precluded from taking full discovery on, which is what we're requesting as that the defendants be not permitted to argue or present evidence.
Oh, yeah,
That
deny
free
that.
speech systems, that PQPR is a distinct entity.
Oh, because they want another
What we
defendant to
were
go
trying
after for assets to
explore is
execute.
their claim that those are separate entities. And so what they should be prohibited from doing is claiming that they are separate entities.
So they get a default verdict against the holding company as well.
All right, so I will
They're
take a
asking
look
for
at
a
it over
default
the weekend.
verdict
Anything further?
against the holding company as well. I thought, didn't they
All right,
get one?
so Attorney Pattis, you wanted some additional briefing. I don't want to be, and I've got a very busy Monday, but I'll make time with other matters, a lot of other matters. So if you can just tell me,
I'll get it in.
give me a time so I can go in and go.
Your Honor,
Oh,
I'm sorry, additional
May I speak
briefing
to
on,
Attorney Sterling?
Not on this issue.
Can I get a time? Noon. Pattis, man, it's like, I don't know. Do you get to an age where you just don't give AF anymore? Like,
The claim is, this was filed by the defendants yesterday. I responded this morning, given some of the rulings and the evidentiary issues. I'd like to add 2 or 3 pages to it to make it better.
Your Honor, I think it would make sense for us to respond in writing to what the defense filed today. I think that might be helpful to the court. So with the court's permission, we'll also file something on Monday on that issue.
Okay, can you do by noon?
Yes?
Okay, very well. Is that it?
Yes.
All right, have a nice weekend, everyone. We
Get off
will
my lap.
see you
Get off my lap.
on Tuesday at 10 a.m. and safe travels.
Thank you.
okay,
Or
so
adjourned.
what I'm going to do, by the way, right now, I can't bring up 2 screens at the same time. PQPR is, I'm pulling up a Bloomberg Law article. It says it's a holding company owned by the right-wing conspiracist and his parents. Said it would pay up to $100,000 for an examination of the bankrupt free speech system. Okay, hold on. I'm going to bring this up. I'm going to leave the screen going in the background, remove, because we're going to rewind on the trial. This is interesting. If anyone in the chat can find the answer before me, it doesn't sound like PQPR, the holding company, is a defendant to the suit. I don't think they are, but if anybody knows, let me know. 420, I get jokes. I just don't do that. Okay, so here's the article. September 1st, 2022. Alex Jones Tide Company seeks probe of InfoWars parents' finances. Okay, this is peculiar. A company partially owned by Alex Jones is asking a judge to allow a court-appointed trustee to review the bankrupt InfoWars parents' finances, a request that could delay the Sandy Hook victims' families' attempt to remove him from the Chapter 11 proceeding, Chapter Bankruptcy Protection. PQPR Holdings Limited, owned by the right-wing conspiracist and his parents, on Wednesday said it would pay up to $100,000 for an examination of the bankrupt Free Speech Systems LLC's finances by the bankruptcy trustee working on the case. Okay, this is a confusing posture here. A related company says it wants to review the finances of the company that the principals of that holding company controlled. Free Speech, a Jones-controlled company which operates his website InfoWars, declared bankruptcy in July after a state court ordered him to pay judgments for the lies that the 2020 school massacre, okay, we got that part, and awarded nearly $50 million. PQPR's motion comes after families of Sandy Hook, in the shooting, asked a Texas bankruptcy court to remove Jones and his bankrupt company from running its operation. Okay, it comes after the families asked a Texas bankruptcy court to remove Jones and his bankrupt company from running its operations and Chapter 11 proceedings. The family's request to remove Jones should be put on hold until a trustee has reported its findings to the court. PQPR said, okay, now I understand. They want the principals out of the operations of the company, and PQPR is saying, no, I presume you can't do that because that will destroy the company, which would be in everyone's worst interest. PQPR, which is listed as one of the largest creditors of free speech, is partially owned by Jones through several LLCs and managed by Jones's father, according to papers. Jones' father and mother also hold interest in PQPR via separate limited liability companies, according to the court records. Having a comprehensive and impartial examination of the debtor's finances is a preferable alternative to protracted and perhaps unfounded, but certainly unnecessary litigation. Okay. Let's just see how much we got there. Sandy Hook families have argued that free speech concocted a $54 million secured debt to PQPR as a way to shift assets and obligations as best suits their needs. The families also want the court to appoint an official committee to represent them as holders of tort claims, which could give them power to investigate free speech finances. Avi Moshenberg, a lawyer for the Sandy Hook families, told Bloomberg Law that they are trying to foil Jones's attempt to shift money. That's par for the course. They're going to go through the finances of all the companies, track all transfers to related entities, all reviewable transactions, as it's called under Canadian law. I don't know what it would be here. Alex Jones appears to be so threatened by the prospect that PQPR is now offering to split the baby with a proposal that lacks the necessary teeth and oversight to hold Alex Jones accountable. Okay. Interesting. Okay, let's bring this back out and let's go back to the trial. Yeah, I see some predictable comments in the chat, which I will not bring up. What did I want to do? Let's go back to the actual trial and just back up a little bit on the day. Okay, so this is the trial here. We're back in. People, let's end it on YouTube actually, and then just go over to Rumble. Here, hold on. Let's just first of all go to Rumble. No, just do that. I'm going to put this up here for a reason, and then I'll post the link. Bring it over to Rumble, people. Let's do this. I'm going to wind it down. I'm going to keep that up there. We're going to rewind some of the trial today, just to some of the highlights and try to make some sense of it. Trial is over for today. Coming back Tuesday because they don't sit Monday. Filing for bankruptcy doesn't resolve anything. In as much as it might delay the inevitable, which it didn't even do in this case, it opens every related entity, individual, up to scrutinizing audits to see when money came out of the company, where it went. Anyhow, so that's that. Let's see how fast the numbers dwindle down here. And we're going to end it in 10, 9, 8, 7, 6. I'm skipping it. 5, 4, 3, 2, 1.